shall file a notice informing the recipient of the Title 4D services and other parties to the case that the 4D attorney represents only the Title 4D agency and not the recipient of the services. And by the way, that notice must state that the 4D attorney may only address issues concerning determination of paternity, establishment, modification, and enforcement of support obligations. And that notice, by the way, must be incorporated in a pleading motion or other document filed with the court when the attorney first appears. Nowhere on there can they address custody and time sharing. It's outside their scope. Did that help you out, man?
So if there's a change in time sharing, that has to be addressed first before the department can step in. As long as I raise that.
Well, I don't know if they have to address it. I think the issue would be as to the department's determination as to how much they're going to claim that you may owe based upon some other set of statutory rules or what have you. They would have to they must consider the time sharing. That's actually in chapter 61. Since we're here, I'll do that real quick before I get out of here. MJ, my bad. What's good, MJ?
No, you good. I was on what Tundra said. Tundra was talking about the time sharing. Now, of course, in the administrative, what happens if you have other kids, the only way to get it considered is the affidavit. But I think it's only okay, because I went through the administrative. I think it probably would be witnesses or affidavits to be able to get your other kids recognized, because they don't recognize time sharing, but that will affect the support obligation.
Right, and don't forget also that for those who don't know, you could always ask a trial court, because a Florida trial court has no jurisdiction over a Florida administrative agency. They don't. But they could actually issue a superseding order that would essentially set aside the department's the administrative agency's order.
Yeah.
So let me see. Are you all looking at the Sunshine online, or what are you looking at? Are you seeing me?
Seeing you. To that point, G, 20 days of them getting a notice of the administrative, they should stay that case in the administrative.
Absolutely. I'm glad you brought that up. Yeah.
My bad.
Absolutely.
No, I just want to throw that in there real fast,
Anybody out there who may be listening later on, yes. Whenever you get that administrative notice or whatever, all my cases were judicial. So wasn't really as familiar with the administrative process, but you can always have the court set it aside. And not only you want to know chapter 61, you want to know in Florida chapter 88 and chapter 409. Let's try this word. And by the way, we do our famous Control F overnights. There you go. So you look at that overnights. See that? And this is 10 from, so 61, something that's 11A 10. This is the one that everybody probably had no idea about for years, and we don't have as large of a group watching now, but I'm sure anybody who watches it later is going to look at that. Can you all see that, what I just highlighted? Can you see that, Derek B?
Yes, I'm screenshotting it right now.
Okay, you want to read that for everybody who might be paying, who might not be here?
The particular parenting plan, a court-ordered time-sharing schedule, or a time-sharing arrangement exercised by agreement of the parties.
Stop. Read that one right there. Again.
Okay.
Or a time-sharing arrangement, what?
Exercised by agreement of the parties.
I think that might answer your question, Tondrick, and yours, Mike.